Hello, everyone. Welcome back to session 2 on the ERA and the 14th Amendment's gender equality jurisprudence. Now, it's my distinct pleasure to introduce Professor Olatunde Johnson, the Jerome B. Sherman Professor of Law at Columbia Law School, where she teaches and writes about democracy, administrative law, anti-discrimination law, civil procedure, and inequality in America. Professor Johnson clerked for Judge David Tattle on the U.S. Court of Appeals for the D.C. Circuit and for Justice John Paul Stevens on the U.S. Supreme Court. Prior to entering academia, Professor Johnson served as Constitutional and Civil Rights Counsel to Senator Edward Kennedy on the Senate Judiciary Committee and as counsel at the NAACP Legal Defense Fund. This is her short bio. You can read her extended bio in the program materials we've shared. It is an honor to welcome you, Professor Johnson.
Thanks for the introduction, Ting Ting, and for all the work that you're doing on this conference. It's been a fabulous morning so far. And the morning's panel really began, I hope most of you were able to attend, by discussing the ratification and amendment process of the ERA. And at the end, the panel began a discussion about the potential impact of an ERA on law, on rights, on policies, on politics even. What would an ERA change about current understandings of equality? And so that's where this panel picks up. And I think that that actually sets up much of the discussion for the next day and a half. A key question that's always been raised in connection with the ratification debates about the ERA is, do we really need this? That's something I heard from the start, even before I was a law student. So after all, there's a 14th Amendment to the Constitution. It has an equality clause. It has a due process clause. Yes, these provisions were designed to address racial inequality and the status of formerly enslaved people, but the language is broad and it's now been understood to address various forms of gender exclusion and discrimination. So the question is, what's wrong with the Equal Protection Clause? How is it insufficient? And what would the ERA really change about current understandings of the Equal Protection Clause? So when we talk about this, I think one of the common arguments for the ERA, and we even heard this at the end of the last panel, is that it might mean that sex and gender-based discrimination would get the level of scrutiny, the same heightened level of judicial scrutiny that you now get for race, and it's now reserved for race. So scrutiny of gender-based discriminations is often characterized as inhabiting this kind of liminal zone of intermediate scrutiny, higher than deferential rational basis scrutiny, but not as high as strict scrutiny. So sometimes that sounds pretty high, exceedingly heightened scrutiny, but sometimes it doesn't sound as high, it sounds less so. But this raises questions. Do we know, in fact, given the current text of the ERA, whether strict scrutiny will in fact occur? Does one, in fact, want this heightened level of scrutiny? There's right now a very rigid and decontextualized approach to discrimination under the Equal Protection Clause, which is sometimes hurt the ability to enact inclusionary programs on the basis of race, such as affirmative action. And so will this bleed into gender? Will it imperil state laws that help women, for instance, advance their economic and social position, like the recent California law on board quotas? And I use that language with love. Another argument for the ERA is that it might help do away with the real differences approach adopted by the Supreme Court that tolerates distinctions and inclusions based on this notion of real biological difference between men and women. And this doctrine has made it difficult to get affirmative protections for women. The Supreme Court used this approach to sustain, for instance, exclusions for pregnancy from disability insurance programs, or to allow barriers to Medicaid funding for abortion. Will this change? Perhaps another argument for the ERA is to avoid some of the pathologies that I just mentioned about the Equal Protection Clause when it's applied to race, and even in the gender area currently, which is that it requires proof of intentional discrimination, doesn't allow disparate impact. This emphasis on formal classifications rather than an anti-subordination approach. So the hope is that a new ERA could really usher in a more expansive idea of equality that attends to historic discrimination, to stereotyping, to conformity with gender roles, and that could affect a wide range of things, such as pay equity and equitable healthcare. So that's the hope. But what would it take to get there? Do courts really have the capacity to articulate or instantiate this broader meaning of equality? And what should be the role of Congress and courts, state legislatures, and feminist social movements in getting us there? So to help us begin this conversation, we have a terrific panel. Their longer extended bios are in the program, so I'll just give short introductions. So first I'm going to introduce Professor Victoria Norse. She's the Ralph Whitworth Professor of Law at Georgetown Law School. She's one of the nation's leading scholars on statutory interpretation, Congress, separation of powers. She's served in a variety of government roles, too many to list here, but including chief counsel to the Vice President of the United States and working on the Senate Judiciary Committee, and the Justice Department, and significantly, she worked on the original Violence Against Women's Act. Her testimony last year on the Equal Rights Amendment before Congress went viral, and not just on Twitter or academic Twitter, but on TikTok. Yeah, that's right. Okay, so she's reaching a new generation. And then we'll have Kendall Thomas, who is the Nash Professor of Law at Columbia Law School here. He's a scholar of comparative constitutional law and human rights. His research and teaching focus on critical race theory, feminist legal theory, law, and sexuality. He's the co-founder and director of the Center for the Study of Law and Culture at Columbia, where he leads a range of interdisciplinary projects, and he is also multi-talented. He's a terrific musician and artist. And then we'll have Catherine Franke, who is our fearless leader. She is the she'll love that, James Dorr Professor of Law here at Columbia, and is the founder and the faculty director of the ERA project. So when she's not doing that, she's writing about law, sexuality, gender-based equality, and race, and is really a very prolific writer, and has recently written a book on reparations that I recommend that everyone read. So they'll each offer their thoughts on the current jurisprudential approach under the 14th Amendment and what they see as the promise of the ERA with regard to equality jurisprudence. So why don't we start with Professor Norse?
Thanks so much. That was a wonderful introduction. My daughter finally paid attention to something that I said because it was on TikTok. So I'm delighted to be here with my friends at Columbia, and I'm so encouraged and inspired by their project on the ERA with Catherine and as fearless leader, and Ting Ting as a fearless also leader. And I'm delighted to be on the panel today. I'm not going to talk for very long. It's going to be a little bit of a different perspective, in part because my experience involving gender equality was first gained in the legislature. Professor Johnson and I are one of the 2% of all law professors in the country who've ever worked in a state or federal legislature. So it was lovely to see her. And my view of the Constitution has been firmly influenced by that. And what do I mean? Well, the Constitution is not, although we do teach this in law school, and I have taught it myself, a plaything for courts. It's not just a set of words. I deal a lot with words and interpretation for courts. Article 1 is about elections as much as it is about anything else, so is Article 2. It is a constitutive document, and women have never played the kind of role in our politics that they should. I view the ERA battle as part of a much longer battle for women to actually take political control of various institutions, because this is a constitutive document. It is something that creates a government as much as courts. So even when we fail in courts, the only reason that the separation of powers is any good is because it's better for voters. We can go elsewhere. We can get elected to our state legislature or to our federal legislature. or work in the White House or all those other things. It's very, very important. And I see the ERA as an important mobilizing moment for young women. And this is why I've decided to invest some time on what I know to be a core problem in the law of gender equality. My experience has been focused less on the Equal Protection Clause for a reason. The Equal Protection Clause doesn't guarantee, I mean, most women think they're equal in their jobs and in their education because of the Equal Protection Clause, but that's really not true. Congress passed something called Title VII, and sex was perhaps added intentionally, perhaps as a mistake, but it's because of a statute as much as anything else. And that brings me to the problem with the Constitution, which comes up from the Commerce Clause. Your rights under that statute and a lot of other statutes are limited by the limitations of the Commerce Clause, and that is one of the sort of odd compromises we've made with both race and gender discrimination. Title VII, as well as the 1964 Civil Rights Act, was supported under a Commerce Clause rationale. And because of that, women's rights have generally been limited to the commerce field. And I'll give you just an example of that. And this has important intersectional components. Good example that I mentioned in my testimony was that people assume that they have an equal right to a job under Title VII, for example, but it only applies to businesses with a certain number of employees. I think it's 15. Someone can correct me on that. They might have changed that one way or another. And that's because it's supposed to, again, have a Commerce Clause connection to maintain its constitutionality. But guess who that leaves out? Leaves out a lot of women. It leaves out a lot of African-American women who have jobs in industries disproportionately based on things like childcare, et cetera, because of historical stereotypes. It leaves out a lot of gig workers who are independent contractors who are never covered by Title VII. And Title VII, as you know, covers both sexual harassment as well as discrimination. And so this is one of those occlusions, you know, that one sees when one takes it, what it looks like a neutral law and applies it to a world that is not neutral, because women are not equal. And these laws that have been passed have been wonderful, and they have opened the world. I could never have, you know, gone to law school without this, never even imagined it. At the same time, they have obvious limitations for young women moving forward. They have intersectional effects that when you start thinking about it, you go, why is it that we're only equal in the commercial realm? And then you get to see things like the Olympians, right? Right before I testified before Congress, Olympians came to Congress to say what had happened. They had been sexually assaulted over and over again by a doctor. They tried to sue. There's lots of difficulties with that. I'm not going to get into the details. But they also went to the FBI, and the FBI stood around trying to think, well, did they have jurisdiction? And why did they have to think whether they had jurisdiction? Because the Supreme Court, in a case called United States versus Morrison, had held that sexual assault is a crime. It's not commerce. They decided this in 2000. And the idea there is just to say, look, your rights actually, since 14th Amendment only covers state action, right? So if it's not a state law, right, it's in a private sector, then 14th Amendment doesn't help you. So let's go to the private sector, and the private sector is about the Commerce Clause. Congress can pass something. They passed the female genital mutilation law, and a court struck it down as unconstitutional. It's crime. It's not commerce. So this ancient compromise of the Commerce Clause, which goes back to some leading cases in the 60s, is a real problem for women because it means that their rights are limited to either state action or the commercial field. So the Olympians, as I said, were assaulted by a doctor. You might think that was in commerce, but because of this Supreme Court decision, there was a serious problem with that. And it remains a serious problem that women's rights are limited to this commerce sphere because lots of things, such as harassment, are not limited to the commerce sphere. Sexual assault, for example, is not limited to the commerce sphere, as we know. And this is the problem with using that frame for all of women's rights. Right? It's simply a partial frame. Now, this also retards Congress's efforts to try to close some of these gaps because of this existing Supreme Court case and another case that involves domestic violence. A lot of what they've wanted to do with respect to gender violence has been thought unconstitutional, and it has retarded a lot of political mobilization around after the Me Too movement. So they've kind of, again, focused on the edges in the employment paradigm and not focused on issues of inequality, of involving harassment and violence. But that's not the only space. I mean, as we mentioned before, there are questions about things like equal pay. There's questions about healthcare. Sex-based discrimination remains on the books, as Professor Johnson indicated. There are many, many areas. It's a bad framing effect to focus, I think, on the Equal Protection Clause, because if it has the state action doctrine, it's going to cover a limited space. Now, I would wish that it were broadened, right? And I'm hoping that if there were an ERA, the equal protection doctrine would be broadened. Women would not be in the intermediate land of intermediate zone and persuasive justifications and all of that, but it's only part of the picture. And that's what I'm trying to emphasize to young women when I talk about the ERA. I think states have tried to fill the gaps. One of the rationales for not enacting more laws related to harassment and violence has been that, well, state law covers that. I spent the last 3 years running a practicum at Georgetown with students. We work for a nonprofit, and we pretty much concluded state law is a mess. And it doesn't protect women. Why? It was built with the common law in mind. So intentional torts have never been developed. There's lots of reform movements that have made it harder, believe it or not. They funnel people into harassment when they're really talking about sexual assault. They make them exhaust their remedies. Medical malpractice says you can't sue doctors. It's an amazing kaleidoscopic set of laws that have never had women at the center of attention. And that I hope the future generation can take some hope, either in the ERA or in some other space, to mobilize around the things that need to be done. I knew that something needed to be done when I heard about Me Too. I had stopped working on these things. I teach constitutional law too. I teach about interpretation. And then I realized that the law really had still failed. So I'm leaning in again. And I don't know what I said at that hearing, but whatever I said made it to TikTok, and I'm delighted because it's time for the new generation to start working on these issues.
Thank you. Thank you for that. That's very helpful. I mean, one, you talked about something that might change, or you say should change, right? Which is the state action doctrine that really limits the reach of the sort of federal constitutional provisions that exist. And one question, well, I guess I have two questions coming from what you're saying. One is more kind of narrow, well, more doctrinal-ish, in the sense of, in some ways, in terms of what you're saying, is Section 2 of the ERA, sort of the enforcement provisions, the analog Section 5 of the Equal Protection Clause, in some sense, the location where it gets realized, or is that not a fair way to think about it? And then I guess the broader question goes to your sort of mobilization point and your kind of TikTok point, which I think is really very powerful, which is this notion that we are constrained by our imagination, right? People often talk about the expressive function of something, the constitutive function, but you're describing very concrete ways in which that gets, realized. So we're not just law professors talking about expressive functions, but we could imagine and actualize something different in the law. So I just wondered if you could say, more about that latter part. I understand it's open-ended and that maybe it's just a continuation of what you were beginning to say, but just sort of on those 2 points, is the part of it that's about congressional enforcement of the ERA something that we really need to focus a lot on? And does it need to be more of an expansive conception than maybe it is under Section 5 of the 14th Amendment?
Right. I mean, you put that more beautifully than I could, our constrained imaginations. I love that term because I think that it has been somewhat, our imaginations have been constrained by focusing on the 14th Amendment, which has many issues with it. and on the courts, because I can tell you that the courts right now, I just spent the last 6 months reading every case from the 2020 term. It's not a pretty sight. We all know this with abortion. I can't see the court giving a huge expansive reading. On the other hand, I think that it would inspire Congress to try harder, and it would open up an avenue for some laws that have otherwise been focused on the commerce clause. It certainly gives you new arguments to make. And there are other realpolitik reasons why the court today might view something like the gender biased remedy in the original Violence Against Women Act. That was the thing, that was the remedy that was struck down in 2000, which allowed you to bring suit against a perpetrator. So at the time, everyone thought we were kind of crazy, but at the time I was like, well, I bet there are some people like Harvey Weinstein. I mean, I didn't use his name at the time, obviously. I would have had to be omniscient. But, you know, that law might have had some effect on, if his counselor had to, if his lawyers, you know, I used to work for a New York law firm, if his lawyers had to tell him, you know, you and your brother could lose everything. I wonder if earlier on he might have actually stopped doing it. But there was nothing, there's nothing in California law at the time. There's nothing in, you know, criminal prosecutions are so rare. This was a civil cause of action, which put the power in the hands of those harassed. I mean, Title VII was never meant for harassment anyway. I'm glad it covers it, but it's got some whole issues with that. So I think the big takeaway for me is congressional action in a bigger sphere that the court would find it hard to strike down. It would be more painful because, you know, I hate to say this, but they have not been, the prediction is they're not going to be particularly kind to abortion laws. They will come under enormous fire. At least one of the members has himself been accused of sexual assault. So the realpolitik of this is, if you had an ERA, I think you'd have a better shot at getting at least 5 to support it. I think the world has also, you know, time tells. So originally I thought they'd strike down the Family and Medical Leave Act for the same rationale that they had in Morrison, but they didn't. And I think that was because there was some experience with this. And it's also because Congress had tried several times and failed. They had failed to try to solve this problem. And when Congress tries and tries and tries, they have a harder time saying no, particularly if and in light of social movements, which have an influence on them.
Yeah, that's helpful. I don't know if, Catherine, if you had a 2-finger on that, or is that, okay.
I just wanted to note that 2 members of the Supreme Court have been accused of sexual assault, not just one.
Oh, really? I forgot that. That's true.
Yeah. So with that, I want to remind folks that if you want to put questions in the Q&A, that we, you know, please go ahead and do that. And I see one that I'll weave in after Professor Thomas gives his remarks. Thank you. So Kendall, on to you.
Thank you, Professor Johnson, and thanks to the ERA project for inviting me to be part of this very important conversation with such an august panel. I am, I suppose, on this panel because what I do is legal theory, and the organizers of the panel wanted someone to weigh in on some of the theoretical dimensions and implications of the ERA. I'm not even sure I can do that. So I think what I'm going to do is to try to use my time to address the question which was given to those of us who were invited to be on this panel. And I'll read that for those of you in the virtual audience who don't have a description of the panel before you. This panel will discuss the foundational work of Ruth Bader Ginsburg as a litigator and Supreme Court justice in building the groundwork for gender equality in the Constitution, and what commentators have referred to as the de facto ERA. This panel will analyze and critique the 14th Amendment's formal equality model and tiers of scrutiny and its deficiencies in addressing inequality today. And I wonder if I may, do I have share screen privileges? All right, so I'm going to do from the start. All right, so I'd like to walk through some slides. Because I was instructed in the description of the panel to focus on the foundational work of Ruth Bader Ginsburg, I'm going to look at one opinion by Ruth Bader Ginsburg, which seems to me to be a central plank in the architecture of the de facto ERA, if we have one. And that is the decision in what is colloquially known as the VMI case. VMI, for those of you who don't know, is an acronym for an abbreviation, rather, of the Virginia Military Institute, and a public institution of higher learning that was created and run by the state of Virginia, and whose exclusion of women from attendance was at issue in the United States versus Virginia. And I want to focus, I don't know why this is happening. Oh yes, I want to focus on this very important passage. It's even famous, of the opinion in, my PowerPoint is running amok, in VMI. This is Justice Ginsburg. The reviewing court asked whether a proffered justification for a government classification based on gender is exceedingly persuasive. The burden of justification is demanding, and it rests entirely on the state. The heightened review standard our precedent establishes does not make sex a prescribed classification. Supposed inherent differences are no longer accepted as a ground for race or national origin classifications. Physical differences between men and women, however, are enduring. The two sexes are not fungible. A community made up exclusively of one sex is different from a community composed of both. Inherent differences between men and women, we have come to appreciate, remain cause for celebration, but not for denigration of the members of either sex or for artificial constraints on an individual's opportunity. So I want to focus on this passage in the opinion, which it seems to me is absolutely central. And I want to do so as a way of addressing the question of the deficiencies in addressing sex inequality that haunt the de facto ERA. And I want to argue as a thesis, which I won't be able to fully develop here, but will sketch out. I want to develop the thesis that the deficiencies in addressing sex inequality that haunt the de facto ERA can be traced not so much to the formal equality model, and specifically the idea that the Equal Protection Clause requires the equal treatment of men and women, right? Of equality as the same treatment. Nor do I think that the deficiencies in addressing sex inequality can be traced to the tiers of scrutiny framework. I think that the deficiency derives more fundamentally from the ways in which the court's sex equality jurisprudence imagines sex and its cultural meaning. I refer specifically to the discursive, and I would add decisional work that is being done by Justice Ginsburg's factual claim about the inherent and enduring physical differences between men and women, and the moral claim that flows from it, namely that sexual difference, or at least the specific sexual differences that Justice Ginsburg posits between men and women, ought to be a cause for celebration. So note the sheer taken for grantedness of the notion that, unlike race and the supposed inherent differences that some ascribe to race, the physical differences between men and women not only signify, but should and perhaps must serve as a kind of pre-political baseline for constitutional adjudication under the Equal Protection Clause. Justice Ginsburg's opinion is blind to how the way in which she imagines and discursively represents sex in the opinion implicates the court institutionally in the production of the sexual difference. And sexual difference here bleeds into gender that we have come to appreciate, right? So the point here is that the court is involved here in the active work of making sexual difference mean one thing rather than another. Moreover, the court's rhetorical representations of sex in VMI seem to me to be not just an act of cultural imagination, but an exercise of ideological and indeed of psychic power. And I was heartened in this regard by the fact that Professor Norse noted that our imaginations in this area are constrained. And I want to suggest that the court's doctrine and the equal protection jurisprudence more generally has been a very important component in that constraint of our imagination. So I need here to make a series of distinctions that I can't really go into fully, but that repose on the notion of ideology. Many years ago, Robert Gordon suggested that what lawyers do should be examined as, among other things, the production of ideology. He noted too that he encountered a lot of resistance among practicing lawyers to the notion that they're intellectuals producing ideology. Very few lawyers, he noted, think of themselves as self-consciously as doing anything of the kind. Naturally, they think of themselves as practical persons occupied with practical affairs, and doubtless this attitude helps to explain the tenacity of the legal technological explanations of what they do. Justice Ginsburg thought she was writing an opinion explaining the outcome in US versus Virginia, not producing ideology. But that language that I read a few minutes ago seems to me to be a hallmark case of ideology that ought to be distinguished from law itself. The French philosopher Louis Althusser makes this distinction between law and legal ideology. And a shorthand distinction would be that law is a formal system which consists of rules, doctrine, legal principles, and the like. Legal ideology, by contrast, is a much more fluid and unfocused and capacious discourse, which is only contingently related to the language of legal rules, and which leans into adjacent discourses. In this quotation, Althusser notes that it leans into the language of morality and notions of nature, right? To undergird, underwrite, support, buttress, right? And secure legal decisions, right? The problem with Gordon's understanding of ideology is that it's a little too conceptual and cognitive, right? So it's tied too closely to the business of legal reasoning with which we are all too familiar. The advantage of Althusser's understanding of ideology is that it introduces precisely this question of the imagination and the imaginary, right? As a source and site for the elaboration of and the institution, in all senses of that word, of law. But I think Althusser's account needs to be supplemented by an understanding of the ways in which ideology also relates to, represents, and encapsulates power and power relations, right? Let's see here. Yeah. So this is the English literary theorist Terry Eagleton, who says that for him, ideology has to do with the modes of feeling, valuing, perceiving, and believing, which have some kind of relation to the maintenance and reproduction of social power. Now, the small point, although I think it is a significant one, that I want to make about the passage that I read to you, in which Justice Ginsburg plates together, right, the statement of what the applicable standard of review is, and this notion of the exceedingly persuasive justification, which is a test she says ought to be applied in determining whether or not a law passes muster under the quasi-suspect classification doctrine of the court's equal protection jurisprudence. The point I want to make is that that technical assessment or evaluation is caught up with and complexly plated together with legal ideology, right? So it's hard to tell where the law ends or begins or ends, and where ideology takes over and does work, right? Now, this notion of ideology, I tried to do a quick search. I found actually one reference to the notion of ideology, specifically to the ideology about women's roles, in Chief Justice Rehnquist's opinion in the Hibbs case, where he quotes from the legislative history of the FMLA and notes that the prevailing ideology about women's roles has justified discrimination against women by virtue of this ideological conception that women are mothers first and women second. So he quotes a statement about ideology, which I put here simply to register the relevance of the idea, right? Now, this question of ideology as distinct from legal rules and of ideology as a site of gendered power is one that Pauli Murray was quite sensitive to. In 1970, in her testimony before Congress, she had this to say: I suggest that what the opponents of the amendment most fear is not equal rights, but equal power. I further suggest that underlying the issue of equal rights for women is the more fundamental issue of equal power for women. No group in power has surrendered power without a struggle. Many male opponents of equal rights for women recognize the more fundamentally revolutionary nature of the changes which a genuine implementation of such an amendment would bring. And so my claim would be that we should start thinking about what is at stake in talking about the ERA today, not just in terms of rights, but in terms of power. And doctrinally, one way to do this is to take a page from the playbook of Justice O'Connor. In the Casey case, Justice O'Connor supplements, and not just supplements, but in an important sense, anchors her substantive due process analysis by putting an equal protection spin on her analysis under the substantial burden test, when she, in the part of the analysis of the Pennsylvania law requiring women to notify their husbands that they are going to seek an abortion, she raises the specter of violence, of intimate partners, but also within family systems. And the question of violence for her is part of the doctrinal and constitutional frame in which she considers specifically the question of the due process clause that is before the court. So she puts an equal protection spin on the due process clause analysis. Justice Ginsburg fails to undertake an analysis that would put a substantive due process spin on her equal protection analysis. And the reason she doesn't do it is because of the circumscribed way in which she imagines gender around the axis of sexual difference, of enduring, inherent, right, permanent, physically based sex difference. And the curious thing, and commentators have noted this, is that both Justice Ginsburg and Justice Scalia in dissent converge around a shared baseline assumption about the nature and meaning of sex. They disagree about the constitutional analysis that one ought to bring to bear, but the basic reality of sexual difference is something that they imagine in overlapping ways. And so the relational analysis of due process and equal protection that is the road not taken in VMI would open up, it seems to me, the court's imagination to understand that what is at stake in the ERA, in the de facto ERA, that is not just a question of equal rights, but the question of power, and certainly not just a question of individual rights, but the question of social power between and among men and women. And that, it seems to me, is work that we cannot expect the courts to do. The imaginal politics that will be necessary to enlarge our horizon, our understanding of sexual difference, its construction, its openness, its changeability. That work is movement work, and it is principally cultural and not legal. Our failure to do that is, it seems to me, in part one reason why last summer, Blake and Thornburg, a Virginia law firm, issued this report commissioned by the Commonwealth of Virginia, which found that notwithstanding the absence of explicit discrimination against on the basis of sex or race, VMI was still wrestling with gender equity and racial equity issues. So we cannot put all our hope in courts, all our hope in doctrinal argument, and certainly not all our hope in standards of review. The work is cultural, and I understand that cultural work as importantly political. Thanks.
Thank you for that, Professor Thomas. That was very rich and in a lot of ways a compliment, although very different in its style of presentation to Victoria's, Professor Norse's comments. And one of the things I was going to ask you about, I think you answered in the end. I had felt some tension between this notion of these conceptions as being pre-political, and maybe the hope that we could somehow through the ERA or some other process change that. But I think your answer is, right, that it doesn't necessarily happen. It doesn't flow from just having the law. What your answer might be is that it flows from the contestation, the articulation, the political movement around the ERA. And so is that right? And then I was also going to ask, but maybe you answer this through this dimension of power, of thinking about power as being the key frame in which we understand this, whether there was some tension between the kind of desire to obliterate, or not obliterate, but at least complicate this reliance on biological difference, and the fact that women historically have so much sought for inclusion and understanding of the ways in which they may need different attention to reproduction, to healthcare. So is that a tension, or is it resolved by thinking on the dimension of power, which allows you to think in a more complex way about how to resolve that? So you can comment on any of that if it's at all clear. And then I have a follow-up question from the chat.
Well, I didn't have time to talk about the work of Drusilla Cornell, which I've recently gone back to, and which has informed my reflections for this panel. She published a year before the VMI decision her important book, The Imaginary Domain. And in that book, those of you who know it, she tries to develop a feminist view of legal equality that synchronizes the values of freedom and equality. And she argues that once we map the relationship of sexual difference to equality, and the relationship of equality to freedom, we can understand why legal equality demands a protection of at least three conditions. which are necessary for the equivalent chance that people have a right to transform themselves into, this is her language, individuated beings who can participate in public and political life as equal citizens. And those are bodily integrity, access to symbolic forms that are sufficient to achieve linguistic skills permitting the differentiation of oneself from others. That's kind of literacy, which you know I'm obsessed about, Alati. And finally, the protection of the imaginary domain itself. That domain in which he says is crucial to the very possibility of freedom, because it's a space where we renew our imagination and engage in the endless process of working through and reimagining who we are and who we can become, right? In Justice O'Connor's binary, bifocal understanding of sexual difference, there is, for example, no space for the masculine feminine, right? And certainly no space for transgender and notions of gender identity that aren't aligned with sex difference. So we're all sexuated beings, but our relationship to gender, and it's worth noting that there's this persistent and productive confusion and indeterminacy in the court's jurisprudence between sex and gender, right? So you'll see in one and the same paragraph, this sort of turn on a dime in the use of the terms. And, you know, I don't know whether it's conscious, I don't think it matters, but I think that it's textual evidence, sort of empirical evidence of the confusion and the productivity of the confusion of sex and gender that haunts the court's jurisprudence and perhaps the larger culture. So I don't know that I've said anything that is any way responsive to the questions you asked, but I just—
It is. And it may also be responsive to this question we have in our Q&A section, which says, we live in a world that increasingly sees a difference between sex and gender. The ERA focuses on sex discrimination and thus theoretically would not include non-binary individuals and others who do not identify with the idea of biological sex. That may be contested, but the question is the ERA as written now outdated? Could there be a risk that a conservative court could use the ERA as a weapon against genderqueer individuals? And others may want to pick this up too. I know that, you could have a comment, Kendall, and also I'll be passing the baton to Catherine. I think Victoria wanted to come in on this too.
You want me to go first?
Yeah, if you want to. Yes.
Okay.
Yes.
So,
please.
I mean, the small point I was trying to make in all my remarks is that VMI's naturalization of gender as inherent and enduring sexual difference forecloses, doesn't just foreclose a relational analysis of due process and equal protection, but a more complete account of the political harm that exclusion inflicts on gender variant individuals. If we understand VMI as a masculine institution, that it denies the opportunity to become citizen soldiers. And so the language of the ERA itself is gender neutral, right? Which is one reason why a couple of years ago, Professors Kimberly Crenshaw and Catherine McKinnon published a piece, I think in the Yale Law Journal, in which they would rewrite the amendment to guarantee equal protection of women in all their diversity, right? I suppose where I would want to go, and this is a pipe dream, I know, but I am struck by the absence thus far of any discussion of how we might try to revive the moribund privileges and immunities clause, which I think in many ways is much richer than the Equal Protection Clause, or at least our understanding of the Equal Protection Clause, as a constitutional source for an enlarged understanding of the gender diversity that we want to protect, right? Under an Equal Rights Amendment, which now has available to it much richer and complicated understandings of what sex is, what gender is, and of the relationship between them.
Yes, thank you for that. And I would put a plug relatedly for the citizenship clause and just the notion of citizenship. It is how a lot of institutions ground their work, and we've made the argument about sort of a richer view of and more expansive view of the citizenship clause. So let me go to Victoria, and then I'm going to send it over to Professor Franke.
I want to hear what Catherine has to say first.
Oh,
Professor
okay.
Franke.
Okay,
I just wanted to
Professor
weigh-
Franke.
If I could weigh in on this colloquy about the fatal flaw of dominant sex equality jurisprudence is that it can't accommodate gender variation. I think it can, and it has, and it doesn't necessarily have to be locked into the kind of story that Justice Ginsburg told us in the VMI case. I like to think of the guys who were at VMI as actually being gender outlaws also. The excessive masculinity at a military institution is apart from the norm of what normal men are like, just as beauty pageants are gender non-normative also in this excessive femininity of a beauty pageant. So I don't want to only think about people like myself who are not particularly feminine women as being the ones who count as being gender non-normative. There are lots of people who are gender non-normative who don't get counted in that story of what sex discrimination laws might want to think about, or just about the variations of what it means to have a sex and have a gender. And I think sex discrimination principles can accommodate that more complex way of thinking it. So I'll make a shameless plug for our panel tomorrow. With Reva Siegel and Serena Maeri, where we're going to talk about how to, and Carrie Franklin, about how to think about sex equality in a way that's not transphobic, that might even better be trans inclusive, but it's hard. And so that's that hard thinking that we're trying to do. So Vic, I don't know if you want to weigh in on this
just
gender
a little
spectrum issue.
Sign of hope here in my other area, my interpretation. Guys, there was a case called Bostock versus Clayton County. And so just give a little bit of hope to the questioner. Even a textualist court decided that Title VII covered under its because of sex language, transgender discrimination and sexual orientation discrimination. And Bill Eskridge and I have written about this recently in the NYU Law Review. And basically, they could have come down without the text. I mean, a lot of it was made up by a hypothetical about Bob and Hannah, but there was also an enormous amount of precedent behind this, because the justices have reached out in these cases to develop it's a small c constitutional, as Bill would say. We in the statutory sphere feel like there is a wealth of law that in the statutory place that can inform constitutional interpretation. And so, now I have to tune in tomorrow to hear what my friend Reva is going to say, but I do think it's possible. And the one indication that this court, however conservative you might think it is, that they were willing to go there. And so that's one reason why I'm less concerned about the precise use of the word sex, if you interpret it as sex stereotyping, than I otherwise would be.
I will say that Bostock is probably the least queer decision that has ever come out of the Supreme Court. It's just horrible, but we did win.
Yes, I know that.
It is very formalist in its reasoning, and it does a lot to avoid sort of kind of history, original public meaning, but it is true that it comes out in a way that is protective. So Catherine, I think you were going to say more behind that issue about how we can think about the relationship between the equal protection clause conception of equality and the hope of the ERA. And there, you could go in any direction that you want on that sort of broadly. I also know that you have had experience with state ERAs that you might also want to have come into this. What do we learn from those? But why don't I just hand it to you?
Thank you. Thanks so much, Alati, and thank you both to Vic and Kendall for setting us up. I want to be mindful to the fact that a lot of the folks who are on listening are not academics and not lawyers. And to some degree, this panel has kind of frame some of these issues in ways that might be a little bit inaccessible to you. So I'm going to try to repeat in a way some of the concerns or issues that both Vic and Kendall have raised, but perhaps in a way that might reach a little bit broader audience. And again, I just want to thank all of you for sticking on Zoom to listen to us talk about these issues, because to us, they're just so critically important, and I know they are to you too. So, you know, in so many respects, the culmination of Ruth Bader Ginsburg's career took place in 1996. 3 years after she joined the Supreme Court and 24 years before her death. And it's in this case that Kendall pointed us to, US versus Virginia, where she convinced a majority of the Supreme Court to embrace the strongest formulation of a constitutional norm condemning sex equality in the court's history. And I'm going to be a little more sanguine, a little more positive about the decision than Kendall was, though I must say I share all of his criticism of it. The new rule articulated in the Virginia case declared that sex classifications may not be used as they once were to create or perpetuate the legal, social, and economic inferiority of women. Those were her words. Ginsburg's aim in US versus Virginia, I think, was to require courts to synthetically interpret a constitutional right to sex equality in a way that wove together the 14th Amendment's Equal Protection Clause with the 19th Amendment's recognition of women's more robust citizenship in terms of voting rights. US versus Virginia instructed courts to ask whether a law or policy reflects and/or entrenches gender-based stereotypes or roles. And in so doing, when they undertake that inquiry, they should do so in a historically situated and substantively critical examination of the gender-based pedigree and social meanings of laws and policies that were alleged to amount to discrimination on the basis of sex. So this is a thick kind of reasoning rather than the formalistic reasoning that we see in the court's most recent sexual orientation and gender identity case in Bostock. So in many ways, one could regard US versus Virginia as doing for sex-based equality what Loving versus Virginia did in 1967 for race-based equality. Loving on the one hand, Virginia on the other. In Loving, the court invalidated Virginia's miscegenation law, a law that prohibited white people from marrying anyone who is not white, on the grounds that such measures were designed to maintain white supremacy. The court arrived at this conclusion based on evidence that the purposes underlying the law were to preserve the racial integrity of Virginia's citizens, white citizens, I would say, and to prevent the corruption of blood and a mongrel breed of citizens. This was in the briefing that was before the court. Justice Ginsburg in the Virginia case recognized a similar kind of wrong that underlay sex equality, targeting the Equal Protection Clause, focusing the Equal Protection Clause at measures that were designed to maintain male or patriarchal supremacy, just as the Loving versus Virginia case was targeting white supremacy. So in the late 1990s, many regarded US versus Virginia as effectively accomplishing the goals of the Equal Rights Amendment. The celebration was wide and very excited. So while the ERA itself was struggling to satisfy the requirements of Article 5, as it still is, Justice Ginsburg got the job done with the majority of the Supreme Court in the Virginia case. At least that was the thinking at the time. It was exhilarating, wasn't it? But unfortunately, it didn't work. Despite the ardent and brilliant efforts of constitutional scholars, advocates, and feminist jurists like Justice Ginsburg, US versus Virginia never delivered on its intended promise. In the end, the courts defaulted back to a sterile form of constitutional sex equality reasoning, refusing to engage in the situated, historical, and substantive analysis that was embraced and demanded by Justice Ginsburg's decision. Instead, what we've witnessed in the aftermath of the Virginia case is an entrenchment of constitutional protections against sex discrimination that more comfortably and regularly protect the rights of men, Of course, this parallels the court's application of constitutional protections against race discrimination that time and time again come to the aid of white people with greater ease than that of peoples of color. Perhaps the best recent example of how the Equal Protection Clause has become one of the greatest threats, in my view, to the promise of equality in this country is the recent decision from the Sixth Circuit in Vitolo versus Guzman. This case involved a challenge to a key provision of the $1.9 trillion COVID stimulus package that was signed into law by President Biden in March of 2021, 1 year into the pandemic. The program targeted economic sectors that were particularly impacted by the pandemic, particularly restaurant owners, providing a one-off monetary lifeline aimed at ameliorating short-term economic disadvantage. Congress built into the aid application process a 21-day fast-track procedure for restaurant owners who were hardest hit by the pandemic, women and socially and economically disadvantaged people, which essentially means people of color. Other restaurant owners who were not women or people of color could apply for aid during this period as well, but the applications from women and people of color would be processed first. Not surprisingly, a white guy, Antonio Vitolo, the owner of Jake's Bar and Grill in Harriman, Tennessee, challenged the fast track application procedure, claiming that it discriminated against him on the basis of his sex and his race. There was overwhelming evidence in the lawsuit showing that women and people of color owned businesses and restaurants were hardest hit by the effects of COVID. Yet Judge Amal Tapar, a Trump appointee, ruled for Vitolo, finding that the government failed to show that prioritizing women-owned restaurants served an important government interest. There was no important government interest in fast-tracking just for 3 weeks these applications from women and people of color-owned businesses. With regard to the prioritization of people of color, the judge wrote, when the government promulgates race-based policies, it must operate with a scalpel. And its cuts, I mean, it's a horrible metaphor, its cuts must be informed by data that suggest intentional discrimination. The broad statistical disparities cited by the government are not nearly enough, he wrote. So the judge's decision in this case, in the Vitolo case, illuminated, I think, so clearly why the existing constitutional prohibitions against discrimination have been ineffective in addressing widespread race and sex-based inequality, and how difficult it is to address and remedy clearly documented disadvantage suffered by women and people of color. And that was the aim of the COVID stimulus package. So why is this case particularly relevant to debates around the ERA? Well, I think it illustrates how important it is to amend the US Constitution, not only to include explicit protections against sex-based discrimination, which of course the ERA does, but also to modernize the way that courts approach the concept of equality more generally. Some gender equality advocates have proclaimed that the ERA's greatest promise would be to elevate sex discrimination claims to the same level of protection now granted to race discrimination claims, subjecting them to strict scrutiny by courts. But the Vitolo case makes quite clear that no one who really cares about equality and knows what they're talking about would advance this position, since the kind of legal scrutiny afforded to race discrimination cases has been entirely ineffective in addressing systematic racism in the United States. Instead, strict scrutiny has been successfully used as a tool more suited to protecting the rights of white men like Antonio Vitolo than dismantling structural discrimination against people of color. The same is true for the sex discrimination protections to be found in the Constitution. When Congress acted affirmatively to address the disproportionate gendered effects of in the economy of the COVID pandemic, indeed 1.3 million women-owned businesses closed during the peak of the pandemic. and that number has just escalated since then, these measures were seen by courts as amounting to discrimination against men rather than reasonable attempts to address structural inequality in the economy. This view of equality requires the government to act in ways that are sexually neutral, even when clear data shows that sex neutrality will perpetuate rather than protect against gender-based injustice. So amending the Constitution now to add a new equality provision as the 28th Amendment would not only add this explicit equality language to the Bill of Rights, but it could and it should be understood to enunciate a new approach to equality more generally. Notwithstanding the ambitious promise of a substantive approach to sex equality embraced by US versus Virginia, the Supreme Court has remained steadfast in freezing the Equal Protection Clause in the 19th century conception of equality and citizenship. So this new 28th Amendment, I believe, could, would, should create a new source of constitutional equality rights that need not be tethered to the framing of the idea of equality found in the 14th Amendment. This would not be a radical or unprecedented idea, this idea of a new vision of equality. We've witnessed in the last year the Supreme Court discover a new source of equality rights in the First Amendment's Free Exercise Clause. Religious observers now have equality rights that they didn't have just a year and a half ago. One that bears little resemblance to the 14th Amendment's Equal Protection Clause and is much more protective of religion-based discrimination than is the 14th Amendment. So the ERA should and could perform the same function. Finally, providing a constitutional mandate to dismantle laws, policies, and practices that reflect, perpetuate, and normalize structural inequality. Courts could be tasked with undertaking that historically situated and substantively critical examination of the gender-based pedigree and social meanings of laws and policies that are challenged under that new 28th Amendment. But even more felicitously, the notion of equality embraced by the ERA could serve as a warrant to courts to modernize equal protection doctrine more generally. As such, the beneficiaries, I believe, of the 28th Amendment would not only be those who suffer sex discrimination, but also race, sexual orientation, gender identity, and other forms of discrimination. This would reflect an intersectional, synergistic reading of the entire Bill of Rights as one document, something even the framers, our founding fathers, intended in 1791. It would deliver on an understanding of the Constitution as a guarantee of full and equal citizenship. The document would be interpreted as a whole, documented as a whole that secured more than the mere sum of its individual parts. So too, I think adding the ERA to the Constitution could be understood as a mandate to federal, state, and local governments to undertake affirmative measures to dismantle sex-based inequality. This could include instructions to the courts also that the Constitution should not be used to disable these kinds of remedial actions by government, as the court in Vitolo just did, and as the Supreme Court has done previously in gutting a key component of the Violence Against Women Act. So as we learned in the discussion that was in the panel earlier today, there are some conservative scholars who hold the view that amendments to the Constitution can only take the form of incrementally perfecting the overall meaning of the Constitution. I suppose those scholars also would find the Reconstruction era amendments invalid, but that's a discussion for another day. But even on this parsimonious view of the substantive reach of legitimate amendments, it would be permissible to regard the ERA as a measure designed to perfect a constitutional notion of equality and citizenship. Or, under a more capacious view of the breadth permitted to amendments, we could argue that the ratification of the ERA as the 28th Amendment manifests a third founding of this country, following the first in 1791 and the second with the ERA amendments. It's a broader view adhered to by some. So there are various ways to think about what the 28th Amendment would mean. In this sense, finally ratifying the ERA would not only be good for women, but it would be good for the very idea of citizenship. Who could possibly find fault with that? Let me stop there.
So thank you for that, Catherine. So I hear you to say many things that I'm not going to try to summarize because you've already said them so beautifully. But I think one implication is that sometimes we overstate the degree to which courts may lack the capacity to articulate these broader equality norms. You know, I come in with a little skepticism. I spent some time looking at the state ERAs, for instance, and they don't have particularly narrow language, but sometimes they're interpreted quite narrowly by courts. But you look at the Virginia case and say, maybe there is capacity of courts on that dimension. You look at the religion cases to say that. And I think that's a very helpful intervention. I also appreciate the intertextual reading of the Constitution as being updated continuously in a way that reflects back on earlier amendments. This is something Reva Siegel has talked about, Akil Amar in different ways, maybe more textual. Jessica Bowman-Pose and I recently drew on that same notion in thinking about the citizenship clause in a very different context. We were talking about new ideas of statehood, but with implications, I think, in a whole other set of areas. And so, you know, that's, you know, a powerful intervention. Do you think anything, so you know, two kind of more prosaic questions flow from that. What makes that in fact happen? So is it the pieces? Does it return to sort of what Kendall and Victoria were talking about in the sense of, do social movements have to play a role in making that happen? That is something that's happened around religion. There's something in the chat about culture wars and polarization. I'll ignore the more argumentative part of that because it's not the level we want to have the discourse, but is there a role here for social movements in that? Or is this just a story of judicial appointments? I mean, is it about constitutional analysis or is it about something else? There's also a question about Ruth Bader Ginsburg and the extent to which she realized this towards the end of her life, right? And in her continued support for the ERA. Maybe she was skeptical of this idea of the de facto ERA. So I don't know if you want to say anything about any of those points before we incorporate some more of these questions in the Q&A.
Yeah. Thank you, Alachi. And again, thank you to my co-panelists for such a rich conversation. You know, I think that where you started your questioning raises a really interesting and kind of unstated provocative question, which is, who is the intended audience for a constitution? Who is it written for? And if we amend this constitution, who are we doing it for? And I think some of us as lawyers and law professors tend to think that the main audience is the US Supreme Court of the 28th Amendment. And I don't think so at all. A constitution is a pact between the people. It is a political document. It is an ongoing conversation or a conversational prompt, if you will, among the people who are organized under that constitution, not just the Supreme Court. And so I want to resist the elevation of the court as the only one who gets to say what the Constitution means. And there's, you know, lots of wonderful writing on popular constitutionalism, but we ought to bring that back into the room about who gets to decide what sex equality means, who gets to decide what citizenship means, you know, even to, you know, re-engage Kendall's question, what it means to have a sex at all. And in that respect, I don't want to surrender the fight we're having now and the way we're talking about the Equal Rights Amendment based on my fears, reasonable fears of what the Supreme Court would do with this text in their hands. Because what the Supreme Court will do with this text in their hands is going to be determined to a great degree by what we do with it first, how we talk about it, how Congress talks about it. I thought the discussion near the end of the last panel about Congress's responsibility to step up and talk about what they mean by adding this language to the Constitution. It has real legal and political meaning. It's not just throwaway lines. They are making law when they're doing that. So are we right now. And so, to come back to where I started, which is who is the Constitution written for? Let's not just say only Chief Justice Roberts or the scarier ones on the court. It's written for all of us, and we have a responsibility to make it mean as much as it can. I forgot what the second part of your question.
Yeah, no, that
jump
says
back
it
in.
very beautifully. And anyone who wants to jump in on that. I was going to weave in some questions in case people wanted to comment on them. I mean,
Make one
Oh, yes.
short,
Yes.
I just want to
Yeah,
say
please.
bravo to Catherine. It was a very, very powerful speech. And I too am very skeptical of the court. As I said, I've just been reading. It's worse than you think if you have to read all the little cases. But I was heartened by when I gave testimony, and I did this because I used to work in politics, not because I'm the leading expert on this. There are many people who are more expert than I. I was delighted, by the way, to hear about Polly Murray from our friend, Professor Thomas, and several people quoted her, but I was delighted that the hearing was very substantive in the sense that I've worked on hearings before, so has Professor Johnson. They can be very, I got enormous numbers of questions from people, J.B. Raskin showed up and others. I was happy they were having a conversation. And I think, and we've been talking to folks on the Hill. I think it's important for them to realize they do have a role in this, that they have a role in shaping the debate and the vision, because many of them are quite progressive. And the way they debate this is very, very important, even if, we know the Senate's there, et cetera. Every little bit of that mobilization is helpful in pushing forward and not giving up, because there really is no choice, in my view. One has to keep putting one's foot one step ahead, even if the 14th Amendment or Ruth Bader Ginsburg's vision has never really been realized. So thank you for that.
Yeah, thank you. Kendall, did you want to get back on this? Yeah.
I want to echo the importance of what I see as a practice of word politics. Right? It's not so much the ideas or even the arguments, but about enlarging the discursive terrain in which we talk about these issues. And that's one reason why, with Drusilla Cornell's help, I was trying to pivot from equality to freedom, right? And that implicates the citizenship notion that I think we've all identified in various ways as important. But even within the terrain of constitutionalism, as distinct from either the constitutional politics that states engage in, or the constitutional law that courts make, I think the language, the effort to enlarge the language and the discursive field, the way we play word politics, should not lose sight of this sleeping giant, which is the Privileges and Immunities Clause. It is true that the court largely has been responsible for the fact that we don't even think about the Privileges and Immunities Clause as a resource, either rhetorically or in terms of practical, political, and legal work. But I think it would be a shame to impose the burden uniquely on the idea of equality, right? And not at least to consider as a parallel track arguments about freedom that I think are uniquely articulated constitutionally by reliance on the Privileges and Immunities Clause.
Yes.
Which is the
On
first clause, by the way, in the 14th Amendment.
yes.
Yeah.
Exactly. And this is very important. And in fact, somebody in the Q&A says that your analysis, Kendall, really meshes with this concept of gender citizenship in Rebecca DeWolf's recent book, Gendered Citizenship, the original conflict over the Equal Rights Amendment, which I haven't read, but I guess describes the movement around it, pre-1972, from 1920 to 1963. And so one question that flows from that is, how can litigation best counter current gender jurisprudence, especially around reproductive rights? Now, my understanding is there's going to be more discussion about reproductive rights, but if anyone wants to weigh in on that, that's something to think about. There's also a question about religion and how it can one, and I think it was Professor Franke, Catherine, you talked about religion, and I guess one question is whether or not this analogy really holds, because the idea of religious accommodation that's going through a lot of the religious discrimination jurisprudence and cases has the potential to undermine some sex and gender discrimination protections. So is there a way to use that concept that the failure to accommodate is itself discriminatory? That reminds me of a kind of Americans with Disability Act type conception. Is there a risk in doing that? What would this even look like as applied to sex or gender? Anyone want to take any of that?
If I can jump in on the religious liberty piece, and I make a plug for the other thing we do in the Center for Gender and Sexuality Law, which is this religious liberty, religious pluralism work through the Law, Rights, and Religion Project, of which Elizabeth Platt, who posed that question, is our director. It isn't that it just so happens that religious accommodation claims have the potential to threaten equality rights. They have been weaponized to do exactly that. There is a well-organized and extremely well-funded set of legal nonprofits that is their mission, is to carve out certain parts of civil society for religious objectors who don't have to abide by the laws that all the rest of us do. And some members of the Supreme Court are quite open to those arguments, and in effect, over the last couple of years, have, as I understand it, or read those cases, created tiered rights. Religious liberty rights really are the top tier rights. Equality rights are second or third order rights, and must yield in the face of religious objectors. But it need not be that way. And let's hope this is a momentary or short-term setback in the expansion of religious liberty rights at the expense of other rights. And to go back to this idea of reading the Constitution and the Bill of Rights holistically, there shouldn't be any that are more important in all cases than any others. They should be read against one another. And there are wonderful scholars who have talked about a limiting principle on religious liberty rights that both respects religious liberty, but also say it has a limit, like any other set of rights might, that has to do with third-party harms. So if someone else is asked to carry the burden of your religious liberty rights by surrendering their own rights or being conscripted into your religious practices, that would be among the places where those religious liberty rights might end up. And if you're interested in more on this, because I could go on more, but I don't want to right now, I would urge you to go check out the Law, Rights, and Religion Project's website for our reports there. And Liz Platt's great work there. Others?
Does anyone want to jump in on any of this, or I have another question before? I know we're going to lose Victoria soon. I have a question that might be suited to you, which is someone has asked about, given some of the challenges that all of you have spoken about, not just in the judicial environment, but in the political environment, what would you advise lawyers, professors, policymakers, activists to be doing right now?
It's never-ending work. It's tiring. You know, I go in and out of this. One of the reasons I do two very different things in the law is because there's secondary trauma I mean, it's very hard. I mean, anyone doing equality work with vulnerable people has an emotional attachment in some way. So it's hard, but my experience is that things have changed for the better during my lifetime. I always knew in 1994 that was not the end. It was just the beginning. And I look to the activists today who are still working, and I gain inspiration. I gain inspiration from it. I think that the states are being are great places to innovate. I'm going to be working with my practicum on litigating some stuff in state law, but states are doing audits for their laws about whether they actually meet gender equality standards. I think that's a great place if it's a real audit, and the real audit has to be something that's not just statistical. It has to actually compare areas of law that are doctrinally separate often. One of the things we've found is that reforms in one area that may have nothing to do with gender, since all of gender is like all law. I don't teach gender in the law anymore because it's all law. One reform here, it might be well-intentioned, but it upsets another reform there. For example, in one state, if you have a sexual assault claim, forget it, because you've got to go to the harassment statute. And another, there's workman's compensation. So if states are working on things like that, that can help litigators as well, because some of these intersections are just unknown. I mean, it's like the concept of intersectionality. You don't see it, right? It's invisible because you don't put these two things together. So I urge people to work on those and to work in your state legislatures to, make that real and make it real across the broad issues. Now, I haven't talked much about abortion. I know that Professor Siegels tomorrow is, going to come with a whole bunch of stuff on that. There's lots of issues. I mean, you don't have to just pick one. Institutions in this country are largely still gendered. Professor Thomas was talking about that, and so did Professor Franke about VMI. We still have gendered institutions. And when people begin to realize that, they say, oh, we can have an influence here. We can do what we can use money. We can, get different boards of directors, and also just get involved in politics. We still don't have enough representation at the state level. That's very, very important. We saw it in Virginia, where women took a very aggressive stand and worked very hard to get the ERA passed. It can be done, even if there are people who don't see eye to eye. The pandemic has made everything very strange, but you can't stop pushing, I think. You can't do it all the time. You might have to take a break. But I love the audit idea. I love people running for state office. But, Danica Rome is now the head of the Virginia ERA coalition or whatever it is. So people of whatever, gender, come on down, because I ultimately think it is a bigger idea, as Catherine said, and it is an intersectional moment. Where people can gain leverage from their partners in, the civil rights movement, in the, ethnic equality movement, because we need a bigger vision than the court has given us. We need a bigger vision.
Thank you for that.
I'm going to have
and
to say
you're going to have to
goodbye.
hop off. So
I'm
thank
so
you
sorry.
so much.
This has been delightful. I should hang out more often with these brilliant Columbia law professors. I'm surprised they let me on the panel. Professor Thomas, I loved your take on power and alter se. Catherine, you can come and give that speech anytime down in Washington, man. All right. And
thank
Elani,
you so much.
great to
We're
see
so
you again.
grateful.
I usually
for
show
your
up at other
insights.
things with you.
Yes,
Thank you
exactly.
very
I'll
much.
see you in the statutory interpretation world.
Yeah. Okay.
Okay.
Bye-bye.
Take care. Bye. Thank you so much.
Yeah. You're welcome.
So, Professor Thomas, Kendall, I don't know if you wanted to say anything on the larger what we should be doing point. I had another question which I lost in the effusive goodbyes, but I will remember again.
I think what Professor Norse is saying is just right on the money. Maybe it's no accident that Virginia also undertook the equity audit of VMI many years after the decision in VMI, in circumstances in which the report notes that there are no explicit discriminations legal discriminations on the basis of sex or race. But what I really liked about the opinion was its connectional analysis, which is not the same as an intersectional analysis. That is to say, the ways in which it connected the experience of students of color at VMI and women students at VMI in a way that puts the lie to what I call the Dave Chappelle fallacy, right? This notion that gains for one group happen at the expense of another, and which open up a space for thinking in a way that can promote and leverage the value of political solidarity, right? Once you see that, notwithstanding the constitutional regime of strict scrutiny with respect to race, or intermediate scrutiny with respect to sex, both students of color and women students at VMI are part of a culture that the report itself described as institutional racism and institutional misogyny. And the advantage of that report, that equity audit, was that it put the old boy network of VMI on the defensive in ways that were contestatory and destabilizing of the normative character of what Catherine called earlier the non-normative masculinity of VMI. Although I think it's quite normative. I mean, the notion of martial manhood has bled over from the military into the broader culture in ways that I think blur the line. So I think that, this is intellectual work in part. It's advocacy work that's not about litigation or about changing the law. It's about changing the terms of the debate and enlarging people's understandings of what institutional racism and misogyny are and why they matter, even when you have a body of good law. And that can't help but be a good thing, in my view.
Yeah. One of the things that I think about a lot in my work is around the question of threats to democracy and also about social solidarity. And I wonder, are there ways in which you can advance a conception of inclusive democracy on the dimensions that we are talking about in a way that enlarges those who are concerned about it, right? Enlarges the pool of those who are concerned about it. So a lot of times when we talk about social solidarity, we submerge issues of race, gender, sexual orientation as divisive issues, right? We submerge them and we say that's the only way we can sort of build a kind of social solidarity. Is there a potential of another politics? I know that's a very hard question. That's one question it raises for me. A second is whether, and you can address any aspect of this that you want, but it goes back to my interest in the fact that there are states that have done state level ERAs, but it's broader than that. It's about whether or not there's something we can do differently in the constitutional process. I mean, right now there's a drafting process of the New York ERA, but I don't know how engaged the ordinary people are in it. Are there ways to make that resonate more culturally? And here it might call on different forms. It doesn't have to be necessarily all just meetings around the table. It could be about art. It could be about music. It could be done in different ways. Do you have any thoughts about that?
That's so great, Alati. I've been working with the folks that have been pushing the ERA in New York State, and I'll say it's a very different text than the federal ERA because it explicitly includes not just sex discrimination, but it's kind of an omnibus anti-discrimination principle of addressing disability, sexual orientation, gender identity, including race, and race is already in the New York State Constitution. But it also explicitly says that discrimination that is not intentional, but discriminatory in its impact is actionable. And it says that affirmative measures undertaken by the state or others to remediate, to address existing inequalities do not count as discrimination, to go to the Vitolo case that I was talking about. It's a great bill. It's really much more comprehensive than the federal law. And, you know, one of my worries is that if we explicitly put that expansive language into place in states like New York, does that mean that the broader language or this less specific language of the federal ERA doesn't include disparate impact discrimination, doesn't include a concept that we can accommodate affirmative action or affirmative measures? Do you have to have it said explicitly in the ERA for us to have that broad reading that I was urging? And these are drafting questions that I think are, you know, the win in one state ends up being the loss in another state, and that's such a drag. But we'll see where that ends up. But to my knowledge, there has not been that widespread, interesting cultural conversation in New York State about why we need an ERA and what it ought to look like and how to get it passed. You know, and Albany doesn't lend itself to that kind of thing. It is one of the most opaque legislative bodies I've ever had the privilege of participating in. But it's not really the state legislature's fault. It's the advocates need to be doing this as well. So I think that's such a wonderful suggestion, Alati, and I'll take it back to the folks, some of whom may be on the Zoom right now, to think that way more broadly about what it is to change our constitutional culture.
Yeah, and I think given how much energy, you know, I'm sure they're expending on just navigating what you just described as a very complicated Byzantine process, you know, that this is where collaborations might work well. And I was thinking a lot about the work that Professor Thomas and Professor Sturm have done with the Theater for Change. So Kendall, I don't know if you have something to say on this point.
I just want to concur. I think that, you know, now is the time to be talking about democratic justice in ways that connect to and leverage racial justice, gender justice, sexual justice, the rights of neurodiverse and physically diverse peoples, in a vision of an inclusive democracy. And, you know, it would be, I'm very sympathetic, for example, to the argument of Heather McGhee's book, The Sum of Us, in which she makes quite clear that racial justice and economic justice are indivisible. And I think that it is possible to do in cultural politics and in our political culture that work, because it's not an intuition, particularly given the dominance of identity as a way of understanding politics today. It's not an intuitive understanding for people. And so I think the educational work that needs to be done, and we're uniquely suited to collaborate and be partners with people on that work. I think the educational work is going to be crucially important. I'm not as concerned about, Catherine, about the dangers of the differences between the New York bill and the federal statute, because as Professor Posen pointed out, so much of what is bad about our equality jurisprudence is a function of its interpretation by courts. I think the people have both a right and a responsibility to be in dialogue with the courts in ways that will, circumscribe the interpretive work that courts do and the lawmaking that courts do under the guise of deciding cases. I mean, the purpose requirement, for example, in equal protection, there's nothing in the text that demanded that. And yet, it is so shrunk the space for making arguments about institutional racism. The court, directly explicitly dismissed the relevance of societal discrimination as a concern. So I think the conversation that we can have in civil society as citizens is really important.
Yeah.
Yeah, so that feeds into what maybe our last question. is somebody asked about whether in the meantime with equal protection, we should be making these expansive equality arguments. And I guess if I'm going to step in a little bit from my knowledge of some of the current cases that are sort of bubbling up around race, I think it's imperative that people make these broader arguments. I mean, if you, earlier in the discussion, Catherine referred to the 19th century understanding of equality. And in some ways, it even does a disservice to the 19th century understanding, because there was an understanding of equality, at least for a moment in time, that could have been something akin to what abolitionists understood, that informed the drafting of the Equal Protection Clause. It has been lost, right? And as Kendall just said, it's unclear what the textual basis for that, or whether it's faithful to the original meaning, even though I don't think those are the only sources, obviously, of the meaning of the Equal Protection Clause. It's also a powerful instantiation, the Equal Protection Clause, of the idea that lots of people who were ordinary people, not judges, who were lawyers, who were enslaved people, bore on the meaning of the creation of the Equal Protection Clause. So right now, to make it concrete, we're at a point in which, when I look at the Supreme Court's jurisprudence around affirmative action, for instance, that the cases that are bubbling up around affirmative action, they're not about racial classifications. They're certainly not about racial quotas. They are about any consideration of race, about the idea of racial remedy is how I've been thinking about them. So even when there's formal race neutrality, it's being challenged. So I think we're in very dangerous territory here, because you're disempowering the governments from being able to enact or be concerned at all about racial equity. And that can't be the meaning of the Equal Protection Clause. So I would say, even in the short term, there has to be advocacy about reclaiming a more expansive meaning of the Equal Protection Clause. That's my little speech on it, moderator's privilege. I would love for you all to comment on it, and also give any last thoughts you have. I think our panel can go longer, but we only have one more question, and there are only two of us on it now. I mean, two of you on it.
Well, I couldn't agree more with you, Alati. And I think some of your other work around the Fair Housing Act and the way in which the Fair Housing Act, among other pieces of federal legislation, it poses a very different way of thinking about the role of equality that builds into it an affirmative obligation to dismantle existing discrimination or disadvantage in the housing world. And so I would urge others of you to look at Professor Johnson's work in that area. So let me pass it back to Kendall. I've taken up too much space here.
Yeah, just, any final thoughts is fine. Kendall, any final thoughts?
Very glad to have been part of this conversation. I've learned so much from Professor Norse and from Professor Franke and from you, Professor Johnson. I look forward to the conversation to come.
Yeah. Well, thank you both. Thank you, Professor Franke. Thank you, Professor Thomas. You've given us a lot to think about and a lot to act on.